formulate, Malas, in very brief, the 7 or 8 points which your lordships were kind enough to give me some time on the last virtual appearance. The first of those points, if your lordship will just keep that note. Have you got the note to my lords? Yes. Whereas the note is, will your lordship just kindly keep it to the side? It will make it easier to assist my lords, which I gave last time. Can the court master kindly give it to my lords? Not a single thing. Does my lord have the note for us?
Yes, I have.
Yes. So the first of those is, your lordship will keep in mind the importance of the case in terms of a level playing field. That's the first point. A level playing field is not just a phrase, not just a word. It has three components which are vital. One, a level playing field is part of free and fair elections, which in turn is part of democracy, and which in turn is part of basic structure. Now, why I say it is because this case reeks of timing issues. It reeks of timing issues. The timing issue ensures that the petitioner is unable, A, to participate in a democratic activity, and B, to try, of course, it will not happen hopefully, but to try and disintegrate and demolish his party before the first vote is cast. The reason I say it is that if your first summons ever is 30th October 23, in a so-called liquor scam of early 22, your first summons to me is 30th October 23, and an arrest is on 21st March 24, then, the timing reeks of basic structure issue, democracy issue, level playing field issue, free and fair election issue. I hope my first point is clear. My lords heard me last time,
Yes.
And my question to myself, which I place before my lords, is what is this imminence? What is this urgency? What is this necessity on the level playing field basic structure argument? As my lord knows, from Indira Nehru Gandhi versus Raj Narayan in 1975, free and fair elections, level playing field, democracy are all held to be part of the basic structure. So I'm not talking politics, I'm talking law. I'm talking the highest principle of the Constitution, which says that even a constitutional amendment, if it violates the basic structure, is unconstitutional. The timing here suggests that there is clearly an unconstitutional element about the whole action. My second point, is the unique feature of this case of no material in any manner supporting under section 50. As my lord notes, the date of the first summons is 30th October 23, which in my note is list of date number 27. I'm shortening it, just to give your lordships the numbers, because otherwise the note is there, very clear. So my lords, has the first summons on 30th October, list of dates 27. The page number is given there. The 9th summons is 16th March 24. That is list of dates number 46. My lords can hear me?
Yes, I can hear you.
So, I was just asking because I can't see my lord's bench. So I don't know what the meaning of that is. Maybe some technicality. But anyway, I'm just pointing it out because I'm not able to know whether my lords is able to see me or hear me. But now, between list of date 27 and 46, now I can see my lord's bench. Now I can see my lord's. Between this period, 6 months plus or 6 months or so have passed. You are clearly doing, therefore, a arrest without any inquiry, statement, material, etc., etc., which can form the basis of the arrest. That's my point number 2. It is unique that there is no 50 at all. Therefore, the 3 words or the 3 phrases of 19 which I place before my lords: 1, reason to believe; 2, material in your possession; and 3, therefore, a connection with guilt. Guilty is the 3rd word. There is no 0 section 50 material. And because there is 0 section 50 material, there is 0 section 19 material. That's the point I'm making. Now, my lords, if my lords will recollect, and that compilation is there before my lords, keep the page. Vijay Madanlal itself, don't go to it, just note the para 159. Para 159 of Vijay Madanlal, which is in my digest, which I handed over. Going to 220, I said 159. Which in my digest, which my lords marked last time with me, is page 4 of my digest. Case law digest, I think my lords marked it also last time.
Yes, I did.
Now that para 159, without going or reading it, is clear that 50 involves the inquiry. And is in that sense preliminary or conjoined with investigation. Because it is the inquiry which enables you, Mr. ED, to make up your mind to some extent about the investigation and the prosecution and the arrest, etc., etc. Remember also that of all the cases my lords is hearing in this jurisdiction, no attempt is made to record a 50 even at my residence. So therefore, my lords, this is my second point, the unique feature of this case. Summons is the primary basis your lordship has been using in many cases, which my lord handles. Ending it there. It is absent. Pursuant to that is absent. Material interrogative, questioning, etc. is absent. Now comes my third point, which is the most important. My not coming to summons, my not responding to summons is a red herring. It's a nice point of prejudice. Let me deal with it in 30 seconds now. My not responding to your summons is a red herring. Why? You did come. I responded, of course, in writing every time in great detail. But you did not have any questionnaire. You did not have any VC. You had nothing. You could have come because you did come to my residence earlier. Whereas you did come to my residence on 16th March. Could you have done it earlier? Could you have recorded a summons earlier? Could you have recorded a statement earlier? Therefore, the red herring that, look, I sent you summons so many times you did not come, is no answer to saying that I have no material on summons to arrest you. That's the very important point to keep in mind. It's nothing but prejudice and a red herring. My third aspect is, and extremely important, the heart of the matter as far as Section 19 is concerned. The necessity, the rationale, the imminence or requirement of arrest. With great respect, I say, please ask this question again and again. Para of the Bansar judgment puts the counterbalancing of 45 with 19 rather well. That is in the page 7 of my compilation digest, but let me summarize it more than reading it. Why it is important in Bansal, please take out Bansal, is page 7 of my digest is the reason that they note that on the right hand, you made the bail more difficult threshold. You made bail more difficult threshold in 45. So-called twin condition, so-called this, that, and the other. Equally, and this equally part even Vijay Madanlal says, you made the test of arrest, the threshold of arrest, correspondingly, counterbalancingly higher and more difficult. The threshold of arrest is not a casual, normal threshold. Under your lordship's normal criminal law, you added specifically in 19 the necessity to arrest test. The bail issue is higher and more difficult. You made even arrest more difficult. That your lordship gets at page 6 of my digest, the extract from Bansal. Para is 15. Just glance at it. I don't want to repeat it, Malas, but please glance at it. It uses specifically this counterbalancing and this Malas necessity to arrest, which is underlined by me 3 times between page 6 and 7 of my digest. I've underlined the phrase necessity. I hope I'm clear, Malas.
Yes.
Now, Malas, apart from the fact that your necessity to arrest is occasioned by completely ulterior motives or considerations. One, this is an old famous saying by somebody, that if I am, I can do anything. Now, power of arrest you have, which means you must arrest, or you have an obligation to arrest, or you can arrest. The test is not can arrest. The test is not can arrest. The test is demonstrate the necessity to arrest, the should arrest test, the should arrest test, and demonstrably the test. Second ulterior basis is the timing after the model code of conduct, after elections are announced. The only object is to insult, to humiliate, to disable. The true intent is disable. Third is that you have not examined remotely any alternate method, that the necessity to arrest will not arise if there is an alternative substitutable method. I can think of 2 or 3: VC, questionnaire, any detailed questionnaire, visits. All of these don't require a obligation to arrest. Your Lordship may take it. Each of my 7-8 replies is very detailed about it. They are on record. They are in my list of dates. They are very detailed. They say, look, these are my answers without you asking me a questionnaire. You have any other question, please send me. There is nothing which you cannot do by this method. Why arrest? Then, Malas, please note in this connection of necessity to arrest the 4th aspect. All this under necessity to arrest, under the 3rd point only, but different facets. What is your CBI FIR, Malas? August 22. What is your ED ECIR? 5 or 6 days later, August 22 again. About a week later, 5 days later. 17th and 22nd of August. All this I am giving your Lordship in a hotspot which calls itself necessity to arrest. Look again at another facet. I'm not saying this is the 45 test. That's not the point. We are on necessity to arrest. So, Malas, the other part of necessity to arrest is this man, can this person be a flight risk? Can he conceivably be a flight risk? What can he do after 1.5 years in terms of interfering with witnesses? You have filed several prosecution complaints. You have filed several charge sheets, the predicate offense, not one. You have recorded statements of some 56,000 is what I was told, 54,000 pages of documents and records. What is it that I can invent today, if I am free, which will interfere with your investigation? Third is cooperation. Which part of cooperation am I not doing unless you say that arrest is the only cooperation or admission of guilt is the only cooperation? 2 things I am not doing. Otherwise, everything you can do without arrest. And then see the remand application at page 378, which itself suggests that they now want in futuro, mark my words, to find out the role of the Chief Minister. Surely that's not a ground of today's arrest, Willis. Just see 378, the lower part. Not necessary, it's here. My lords got it?
No,
378 plus.
378. Yes, 378.
The lower part was I, that the arrestee is required to be interrogated with respect to his role, marks the word, and the aforesaid statements to unearth the remaining proceeds of crime. Now, this can't be
Page
ground of
number is
arrest.
wrong. Page number is wrong. My learned friend is referring to some wrong page number.
But
378
this
is the
what he
prayer
was
for
reading.
rejection of the remand.
No, that 378 that I have. This is
378 which I have is an application, a reply to the remand saying that remand should be rejected.
Correct. Well, it's 378. Let us see first whether what I'm reading is what is matching the judge's copy. What I'm reading is that the arrestee is required to be
It
interrogated.
should
with
also
respect-
match with my copy. You can then I am not I'm not required if it is to be matched between other persons. It has to match with me. How do
I don't understand what is my
you
getting
don't
so
want to
excited
understand,
about.
Dr. Singhvi. The point is you're not
Getting
giving
so
me the
excited
correct
about.
copy. That's the point.
can
I
tell
don't
you the
understand.
page number. We can tell you the page number.
You can. There are people to assist you and find the page. Why are you saying that it's not matching the wrong page?
I have the hard copy.
I don't understand. Yeah, it's not matching his copy. Don't answer the
PDF
question.
page 380.
So 2 pages away, he is. So why is he making all these complaints? As if we are trying to suppress something from him.
It's
I hope
not a
that's
question
the
of
best
suppressing.
argument.
It's not a question of suppressing.
2
It's a
pages
question
away.
of not
That's all.
giving me the copy.
Page number.
I have a right to a copy. It's not a question of suppression.
The PDF page number.
Take
How
no
can you
copy.
please check it?
Something.
Just
Even kindly have a look at my hard copy, which is a 378.
You put one of your people standing next.
This is a,
Tell your correction of pages. There is a difference. Well, is it in your lordship's 378?
let him please just give us 2 seconds. Just give us 2 seconds.
even the hard copy given to me is different.
I didn't do these things.
And then he shouts at me.
I think the person who's shouting is the SG.
No, I'm not.
It's wrong copy. Yes, you are. Very
No,
much.
I'm not. Sorry.
The page numbers are different.
We have replied on the page. Our reply is on the base of this. If you have
As
a
my lord,
separate,
what I will is 378 first. Let us get your lordship's copy right first.
Our page numbers are different.
It
What
yourself.
their page numbers
now
are.
kindly have a look at my hard copy which is supplied to me. Different.
Then can you please give them a copy?
How do I argue the matter?
Mr. Chaudhary?
All my points have been recorded on those. Kindly have a look at this.
Can somebody
Once
please from
first-
your side tell them?
Well, I think there's some confusion. The original petition served was not dated on their defects were applied. We served them fresh petition also. It's in the mail. Maybe,
You
Lord,
give
there is-
another copy.
We'll give another copy, Lord. Let's cut this controversy.
They said.
Lord, we have 2 mails. Let's not get into this. I'm giving him a fresh copy. Give him a fresh copy. Given.
If he is giving
Fresh
me a
copy is given,
copy,
Lord.
it may be kept tomorrow. I can't argue on the basis of fresh copy. Running into 500 pages.
It's all, I think, a ruse to get an adjournment.
No, I know it's not a ruse.
It's all right, Lord. It's between lawyers. What is the problem? We're giving
It's
the
a
copy.
complete ruse. It's a complete ruse to get an adjournment because a 2-page difference is happening between the original copy and a defect removed copy.
Tomorrow.
The mail is sent saying, please ignore the earlier one. The mail was sent on that day. Let's not get into this, Mr. Raju. We are far above this.
Copy which it's not a question of getting into it.
We are giving you a copy,
You are
brother.
giving me a wrong
I am
copy.
saying,
Wrong paginated copy. How do I reply? You're referring to pages which do not correspond with the pages given to me.
well, Lord,
And don't oversimplify the thing.
there are,
Now, all that has happened is a post-defect copy was supplied by email. My learned friend's assistance.
1 second.
No.
There's an 8-page difference in both the copies.
Then they have to supply
Lord,
the correct.
I'll just, Lord, make it clear. Give me the dates of both the mails.
It has been supplied by email. The receipt is there. Everything is there. If they are not using it, it's their problem. But we'll give another copy.
One more second.
But Lord, there are,
She is now referring to the document itself, I think it won't be too difficult for us.
Correct, my lord. It's nothing more than that. Document.
So we are reading, and I will tell you what he's reading. He will tell you what he's reading, and from this side, you will please tell him the.
Please, will
I will
insist
put, I
not
will
with the
put
page.
one of my persons standing there will give the correct page
Now we are
immediately.
reading-
Please put a person,
now
give
we
a
are
name.
reading the remand application.
Mr. Rajat is there, he will give the correct page immediately.
We will adjust. That's not the issue. We will adjust. We will adjust by 8 pages. The issue is a wrong copy has been supplied to us, which should not have.
My lord, I think that's with due respect to my learned friend. Well, let's
That's
proceed with it. Let's not while away time.
The correct email was sent, your juniors picked up the wrong copy and briefed you on the wrong copy.
Mr. Singhvi will conclude by lunch.
Juniors
Lord, he'll
picked you the wrong
conclude in
copy.
5 minutes.
Second, now we are please. Now we
Give
are
us a correct copy now.
the remand copy, remand application, and we are reading.
Yes, yes.
Parent number.
I'm reading
Parent number.
378 of my Lord's file, and Mr. Rajat in the court will immediately open the file to the correct page and hand it to Mr. Raju for the 8-page difference.
I just want the parent number of the application.
13I, 13I, 13I.
Right. So now we are reading. Yes, we are reading
PDA page
file
384.
of the remand application, and you will have now. You will please tell him the correct page number.
Mr. Rajat,
You will
please
tell
do it.
13,
Already done.
The PDA page 384.
13 small Roman 1. It's 13 small Roman 1. Otherwise, we'll again have a confusion about this. It's 13 small Roman 1.
That the applicant directorate has complied with so and so, that the arrestee is required to be interrogated with respect to his role and the aforesaid statements to unearth the remaining proceeds of crime. And for this purpose, it is imperative to have custodial interrogation. So the application of the ED is itself saying that we need, after 1.25 years of the original FIRs and after 6 months of the first summons, to find the role of the petitioner, and for that purpose to find the role, which I don't know after 1.25 years plus after 6 months, I need his arrest. That is the point which I was trying to make with us. Now, this completes my third point. The law related to this third point is just take the digest, read a few parts of it, take the law digest. Please leave this.
What do you want to read?
The law digest which my lord has got. First turn to Pankaj Bansal.
Do we have it?
See, the problem is make this small, you to make this large, but it's so big. That's very. Pankaj Bansal starts, make it small, completely take it away. It's small, stop this thing. Come to Balab's page 5. So, please close this, is not necessary. Does my lord have Balab's page 5? Item number 2 is Pankaj Bansal.
What do you want to read the judgment?
Yes, on this point, necessity to arrest. The necessity to arrest. The second item is Pankaj Bansal, the extracts. The page is 5 of the extracts of the judgment. Where is your lordship just had it? My lordship had it 2 minutes ago. Lordship, you got that?
No, I think you please give me the copy. There's some confusion about what I have also.
No, the case digest is not there. Lordship, in fact, marked it last time. Anyway, give it again, please.
That was from VC maybe.
Kindly give it, please.
So I have it here.
We're giving a fresh one.
So page 2, item number, serial number, go by serial number 2 is called Pankaj Bansal.
Yes.
It's a later case. And this is much faster because it gives the extracts. I have taken the liberty of underlining. One argument made is, Vijay Chaudhary decides everything on 19 because 19 was challenged. 19 upheld in Vijay therefore end of the matter. So Bansal clarifies in para 11. My lord has got it?
Yes.
The finer connotations and nuances of the language used in 19, to the extent left uncharted by Vijay Vandarlal, was still open to interpretation and resolution. Then, Malas, the only issue for consideration is whether the arrest of the appellants under 19 was valid and lawful, whether the impugned orders measure up, In that context, we may make it clear that the mere passing of an order of remand would not be sufficient in itself to validate the appellant's arrests, if such arrests are not in conformity with the requirements of 19. So first thing is, Malas, the argument is made, oh, now it's remanded, now where is the question? And today I find, Malas, an extraordinary point, at least from the press and from the counter. Just bear with me for a minute, Malas. Kindly allow me to digress for 30 seconds. The counter says that because the accused himself said in a proceeding going on that he does not challenge custody at that point, therefore a prior matter which has been heard by a lordships prior for 2 hours that day, a prior petition coming up for today is rendered infructuous as if we are dealing with some kind of a civil matter where the accused is stopped to say now that section 19 arrest is illegal. It's an extraordinary plea in a counter. It's a plea unheard of in law. The counter takes the plea that because the accused said in the court of the trial judge that I am not at the moment objecting to custody, I had argued before my lords 1 week ago. The 19 petition is earlier. Your lordship is hearing it. And therefore the accused is supposed to have given up. Will you give me the counter when they say so? That's all. We'll cut him. Now, the third thing. Come to para 15. That is the next page of this Pankaj Bansal. It was noted that section 19 prescribes the manner in which the arrest of a person involved can be effected. It was observed that such power was vested in high-ranking officials. Apart, section 19 provided inbuilt safeguards to be adhered to by the authorized officers, a recording of reasons, belief. Such reasons have to be recorded in writing. While effecting arrest, the grounds of arrest are to be informed. Then, 4 lines below, forming an opinion as recorded in writing regarding the necessity to arrest. Necessity to arrest. Then, next part, continuing para, in the next page, continuing, it was concluded the safeguards provided in the Act and the preconditions as contained